Feminism, who is our partner in the launch of these webinars. We have spent some time really thinking about what it means to produce feminist-led legal knowledge on the continent. And it is something that we do know. We were told about the contradictions of using the master's tools to dismantle the master's house. And here we are, and we are saying that we can use the law as a tool for social change. And what we hope to do in these webinars is to be able to document the various strategies that ourselves and our partners embarked on over the past number of years to think about how the law can be a tool for social change in order to advance women's rights and the rights of LGBTQI people on the continent. So you are very much welcome to these webinars. And what I would like to be able to do now is to introduce our panelists who are going to join us today, and also the person who helped us to do the blog. So if you go to African Feminism website, you will be able to see a blog every Thursday, and that blog introduces each and every publication that we will be launching on that day. We are very much happy to be joined by all of you. So yes, please do write your name and introduce yourself in the chat box. This is supposed to take place for just 90 minutes. And so we will have a conversation. And then after the conversation, we are going to be able to take your questions about this. I'm going to start with the core panelists, the people that we are going to be in conversation with. And I am going to let Dr. Abiola Akiyode-Afolabi introduce herself, and then she will be followed by Dr. Mariam Kamunyu. So welcome everyone, and welcome Dr. Akiyode-Afolabi and Dr. Kamunyu. So I would just like to introduce yourselves to our panelists, to the audience for now, and then we can take the conversation forward. So thank you very much, and everyone welcome.
Good morning. It's a pleasure to be here. I'm Abiola Akiyode-Afolabi. I'm a women's rights feminist advocate based in Nigeria, Lagos, the head of the Women Advocates Research and Documentation Center. I'm also I'm a lawyer. I also lecture at the University of Lagos. I can't start my video, so I don't know why. So I need to get the host to allow me to do that.
Please unmute and let's see. Yeah, the pictures, please. Yes. We saw you just briefly.
I think it's better now.
Fantastic. Yes, that's right. Yes.
Okay, thank you very much. I think you heard me. I said I'm Abiola Akiyode-Afolabi. I'm the Executive Director, Women Advocates Research and Documentation Center. I'm a feminist, I'm an attorney, and also I teach at University of Lagos. WOTC has been around since the year 2000, and we have been experimenting and supporting strategic litigation, for a while. So it's a pleasure to be here. And I want to thank Isla for putting this together. You've been so consistent in ensuring that we build this body of knowledge. So I really thank you for what you do. Thank you, sister. Good to see
you. Thank you so much for that introduction. Dr. Kamunyu.
Okay, good afternoon. I also can't start my video. I think I need to be permitted to do so. Great. Thank you. Hi, everybody. Good afternoon from Nairobi. My name is Mariam Kamunyu. I am a feminist human rights lawyer. In this life, I wear two hats. So I identify both as an academic. I teach international human rights law and gender and the law, and as well, I'm a practitioner. I practice as a human rights lawyer with a feminist inclination, which therefore means I have this interesting relationship with the law where it's both the boon and the bane of my existence. So just consistently questioning the various biases that exist in the law, particularly for women and sexual minorities, and therefore just trying in my work to surface these biases and to see what it is that we can do about them, whether it's surfacing them through publications or working on litigation or various advocacy endeavors. Very happy to be with everyone today.
Okay, thank you so much for that. Fantastic. I am going to hand over to our moderator, Nobukosi Zulu, who has joined us very recently, the team at ISLA, but she's a person who leads our knowledge production work. Over to you, Nobukosi.
Good afternoon, everybody. Thank you. I was just trying to turn on my video here, but I'm sure our tech team will get to that. So thank you, Sibongile, for starting. And thank you, everybody, for joining us. Seeing as our other two panelists have already introduced themselves, although you may think you need no introduction, I'm going to ask Sibo to please introduce herself.
Okay. Thank you very much. My name is Sibongile Ndashe, and I am the executive director of the ISLA. I have been involved in strategic litigation on women's rights for the past 20 years. My background, I think that's where I have met most of the panelists and some of the people who are joining us today. The work that I've been doing has really been around strengthening capacity of lawyers to do strategic litigation on women's rights before national courts, but also litigating cases before the African human rights system. And of course, we don't have a lot of those cases, but to have contributed to some of the jurisprudence that we see at the African Commission has been one of the joyful things to do. So obviously, we are talking today about feminist knowledge production, and I think this is something that I've also really been thinking about. How is it that whenever we're talking about feminist legal methods, you know, we are talking about all the stuff that is very good, but that we have borrowed, and what does it mean to have African feminist legal methods? So that's me, and yeah, that's what I do when I say I'm working.
Thank you for that. So this is really exciting because this is the first of a webinar series that we have launching a series of knowledge that ISLA has worked very hard on and collected over the years. And so this is our first one, and I'm very excited about that. And so we're just going to get straight to a conversation with our panelists. And I've got a few questions that I'm going to ask our panelists around this document that ISLA published. Before I do that, perhaps there's someone who actually hasn't read the publication, so I'll just give you a brief summary. This publication is a document on case sourcing for gender and sexuality cases around the continent and some of the challenges that come with that kind of work. And this is important because we know that there is a dearth of cases around issues that have to do with women's rights and the protection of those rights. And in our lived experience every day, we all know that there is all kinds of abuses and human rights issues that take place, but there isn't enough cases that actually end up being litigated, being finalized, and women go through lives without any real recourse or them accessing the available remedies that are available in the law. And so this document looks at this publication, looks at that, and looks at the challenges that are there. And it is through, it's come through a work that has happened over multiple years from ISLA. And so my first question really around this knowledge production, particularly around case sourcing, is to you, Sibongile. And my question is, why did ISLA decide to study this particular topic of sourcing?
So I think that one of the big things was that we had been around since 2015, and we were doing this regional work. And when we wrote our initial concept note on why ISLA needed to exist, it was because we were decrying the death of cases before the African regional human rights systems, because the statistics, whenever I ask people, how many cases on women's human rights do you think have been taken to the African Court on Human and People's Rights or the African Commission? I mean, the African Charter has been around for the better part of 40 years. No one can actually guess, because when people think about the face of rights violations, most of the time, African women's rights faces are often represented and overrepresented there. And so when you think about holding the state accountable for the failure to protect or advance women's rights, you would think that there has been a case. And so normally I just say yes. And for many people, it just doesn't come that there've only been 2 cases at the African Commission, you know, in way over 30 years on women's human people's rights. And then I say, let's go to the African Court. And then it's like a very big one, you know, case that has been taken there. So that's one of the things that made it important to really try and understand why is it that when there are so many violations, you know, that we know of, that people still are not going there. And unfortunately, this was not something that was only limited to the regional human rights system. It was also when we went to at country level to say, how are the courts doing? You know, how are we developing jurisprudence? And I guess this envy kind of came from the job that I had before this. So I worked for an international organization that litigated before the regional human rights systems, but most of the courts cases were before the European Court of Human Rights, although I was tasked with leading the equality work in Africa. So I always felt envious, you know, my colleagues are going to court in the European human rights systems and they are talking about this provision being developed, and this is the state obligation standard, you know, these are the normative standards that are being developed. And then every day it's like a struggle for us. It's like, okay, I found a client, and then no, it's not going to proceed. There are provisional measures that the person would want in order to be able to proceed, but this is just not happening anymore. And so it was just trying to find out what is it, whether as lawyers that we were doing wrong, but what were the conditions that said, even though we've got this kind of proliferation of human rights standards, but why is it that we are not using the treaty bodies? You know, are we not using the regional human rights mechanisms or the constitution that we had in order to take on these kind of cases? So that's where this kind of thing came from, to say, if we understood how to support the clients better, how the legal institutions sort of worked to either create an enabling environment or to stop people from going to court, then, you know, we would be in a better position to really understand and also respond, you know, to this issue of why is it that we have 1 in Arusha at the African Court and we have 2 in Gambia at the African Commission.
Thank you. That is very interesting. I think it's very sad if you think about it, when you consider that women, there's so many of us and we know that our issues are so deep, but we are not being represented in our cases, are not going through. And so in your journey of finding and of asking these questions and realizing that there was this dearth of cases, what did you learn about the different types of clients and their roles in litigation? Would you say that you had the same considerations of those clients apply to LGBT cases and general women's rights cases?
So one of the things that kind of excited me as a young lawyer, in the early 90s as a law student, I think at the time, was just seeing, I think after Beijing, some of the cases that were coming up, or even before that. So seeing Unity Dao versus Botswana in Botswana, challenging the failure of the law to kind of allow women to give nationality, of their children to their fathers, or seeing cases like Sarah Longwe in Zambia challenging like irrational practices that women who were going to a Holiday Inn hotel needed to be accompanied by a man, otherwise they would be denied access. And then kind of over the years, just seeing how women were able to actually say they'll go to court. So in Zimbabwe, kind of Margaret Dongo, and so it just continued in Eswatini, Duapane, and a whole range of other women. But there was something that the women who were going there by themselves had in common. They were activists, they were women's rights people. Some of them were lawyers and all of them. And so one of the things has been about legal empowerment being really key, because you either know what you are entitled to, and then you also have the means to be able to pursue that. And we continue to see this in South Africa, that some of the cases are either identified by a public interest organization, where you actually have lawyers that are trained to do that. And sometimes it may be a law firm or a women's rights kind of organization that says, no, something is wrong here. But there was something about the client who were willing to go there. In LGBT cases, I think something similar has been recorded across the continent. When you look at the cases and who are the people who have been at the forefront of these cases, that is using the law, who are using the law as a tool for social change, you'll be able to see that in South Africa, for example, it was the National Coalition on Gay and Lesbian Equality. And this was an institutional, an NGO, really a social movement that was, and there's a big difference obviously between an NGO and social movement at the time, that was advocating on these kind of issues. And then when you start seeing the cases in Uganda, around 2006, Victor Mukasa and Yvonne, that the people who were there were activists, they were leading a movement. It was, this is not going to happen to me. We go to Kenya, we see the Nigel Herc cases, the Eric Gitari. We go back to Uganda, we see Kasha Jacqueline, we see David Kato, we see Pepe Onziema. You go to Botswana, you also see Liga Bibo and kind of other activists doing that. You go to Nigeria, you see Pamela Adi. But it's like there are people who are saying, not on my watch, not in my body, who are going to take on these cases. And some work, the work that I did when I was at Interrights was really about doing litigation surgeries, inviting lawyers to say, if you have got these cases, come, let us workshop that so that you can go back. And I am going to give you a very sad statistic, that every year we went to Kenya, Mombasa, with 12 lawyers, and each one of them had a case that from 2009 until 2013, when I left. So if you say 12 times 5, you get 60, like 60 cases that came to the surgery, and they were workshopped. We developed the arguments. Some of them were briefs. The only cases that went all the way to judgment were only 3. And what did they have in common? Movement leaders or NGOs that were taking on the case. So that was one of the things that we had kind of going into this study, to say we need to pay attention to the people who are going to court, what motivates them, that there are many people who are victims of rights violations, but not everyone is willing to be that client, who takes on a case for strategic litigation. People will go to the police, to report the case, but that does not necessarily mean that they want to be the one who holds the state to account. And this also happens, I think, with organizations who are happy to take on cases of domestic violence, of maintenance, and other issues against the defendant. But once you say it's actually the state's failure to protect, then, because they don't want to mess up their relationships with government. So it's the political orientation of the organization that then determines whether they are going to go forward or not go forward. So these are some of the things around what motivates people and who are the people who are most likely in these kind of cases. And finally, I think it was important to make a distinction between other rights violations, other civil and political rights, that are violated, which do not focus on women and LGBTQI people, because the fear, the stigma, and all of those things, the violations themselves, people not wanting to take on family, maybe in issues of inheritance or divorce, and how these were kind of contributing to people not going, to court, as opposed to, or instead of other cases where you found that the people who are not, people who are in prison already, and they have organizations that want to help them to take on kind of fair trial issues, that those are the cases that were likely, to proceed. So when you look at the jurisprudence of the African court, most of the cases that are there are cases on fair trial.
Thank you. That's so interesting. And what I'm hearing come out a lot, listening to you talk, is about this interesting way in which ISLA seems to be working across the continent. Your collaborative knowledge production method, because you were working on gathering cases in your previous work, as well as in the work with ISLA, and partnering with many different actors across the continent that are working on these women's rights. And I think, and that's what makes this publication so unique, is that it is not looking at any one country or jurisdiction, but it is looking at the broad challenges that are faced around case sourcing for gender and sexuality, and not just in one place. And I think that's absolutely amazing. And I'm going to move on to our next panelist, Dr. Miriam. For all those who are in attendance, please, I know you have a lot of questions for Sibongile, because she's just given us massive knowledge burst. And so please keep your questions. We will have a question and answer session after our panelists get an opportunity to present. Dr. Miriam is the amazing lady who worked on the publication for us. And she did all the academic work and put the publication together. And so we're very honored to have her here. Dr. Miriam, thank you for joining us today. My first question for you is, as an IPE member, what was your experience of the collaborative knowledge production model?
Great. Hi again, everybody. So I think my experience, and maybe just to make it clear to everybody, the collaborative knowledge production model is just where this idea or this working methods that ISLA has, where, for instance, when you get a job as a consultant, this knowledge production is something that's very collaborative. There's various, the knowledge is very experiential, coming from various sources. So that was very fulfilling for me, because ideally, the life of an academic and the life of knowledge creation is a very solitary and a very lonely experience. So in this case, it was very, very fulfilling to be part of this co-creation process, whereby the knowledge is coming not just from literature review, which was consulted, but also just the knowledge is very much experiential. And that's really something that's really significant about this publication by ISLA, in that the knowledge is very experiential, in that it's based on the experiences that you're hearing Sibongile talking about. It's based on the experiences of various ISLA staff, their various challenges as they've tried to source for cases. Also from various other social movement actors that we put together in a room. And so in that case, the knowledge is very, very real. And so there was this very nice merger. So as an academic, what you struggle with is producing knowledge that is very abstract or very hypothetical. So in this case, there was this very nice co-creation process where the knowledge is solid, and then it's also based on the lived realities of practitioners. So that was very, very fulfilling for me. Very, very fulfilling. I felt like a super executive producer.
I'm glad. And the publication is so well done. It speaks to the way in which you enjoyed putting it together. So you spoke about the experiences that you were working on, lived experiences of practitioners. And so when you looked at those lived experiences, what is it that was found between the lived experiences and the academic literature? Are there areas that are lived experiences by the practitioners in cases around gender and sexuality case sourcing that the literature doesn't discuss, showing the gaps between academia and practice? Did you find that when you were putting the report together?
Right. So the answer to this is yes and no. So yes, when you think of the broader challenges associated with, when you're looking at literature review and you think of the broader challenges associated with strategic litigation, even feminist strategic litigation for gender and sexuality cases, you do find that there's a lot of literature on challenges once you have the case, so you could find, for instance, things speaking to attrition or how to have effective strategic litigation. So that exists. But where there's really like a distinction between the knowledge in literature and that which we found that I was able to get from this experiential knowledge is that, for instance, when you ask yourself, what really is the dearth behind these cases? Because remember, what are we saying is was our grand research problem. We're saying, on the one hand, if you look at our continent, awash with violations of women's rights and sexual minority rights. And then if it's a CISO scale, right? So it's very violations, and everyone in this forum here could name 2 or 3. And then when you look at the cases, it's hectically disproportionate. So you're seeing, so what we're trying to find out then is, where is this? What are the barriers? What is happening here between where we have millions of violations and 3 cases before 2 regional courts? And so that is where that is what literature won't answer for you. So if you go to literature right now, that's the question that literature won't tell you. It won't tell you, why don't we have these cases? What are these barriers to case sourcing? So that's one of the things that where there was really like a great dearth, and where I benefited really exponentially from hearing from the people that were in the room. Another thing that stands out is the disconnect. And when we get into now the issues, for instance, when we look at some of the violations that you could think of, for instance, from a sexual minorities perspective, another disconnect between literature and the experiential knowledge is, let me try to think of an example. There's this disconnect between, so if you're to think about the issues that you would bring in a case, let's say it's for sexual minorities. So for instance, literature will show you that, the hot button issue when it comes to litigation of sexual minority rights is decriminalization. And I also came into the room, I also came into this process thinking that, of course, this is the main issue. And, and the reason for this is that where the law criminalizes same-sex sexual intercourse, there has tended to be a misunderstanding that LGBTI persons themselves are criminalized. So following from this grand presumption, donors and, NGOs, we have then been guilty of then pursuing decrim of sodomy laws, of same-sex laws as this panacea. We see it as this panacea to discrimination, and this is reflected a lot in the literature. But what I learned, and now from this experiential knowledge of, these practitioners, and particularly those ones who are connected to social movements, is that decrim actually isn't the cause of the everyday discriminations that sexual minorities, LGBTI persons are experiencing. Yet this is the focus when it comes to, for instance, pursuit of strategic litigation. And they were saying, for instance, what we are more interested on is cases that would pursue vagrancy laws or laws where LGBTI persons are discriminated in the case of immigration or with regards to access to employment. And so this knowledge, this knowledge was then learned from the lived experiences of actors, of social movement actors, as opposed to literature. And so I'm saying this example is important for our perspective because when it comes to case sourcing, it's very critical to identify the right issue. And what the right issue is often cannot come out of literature. And when, for instance, when you think of the types of clients, and if the client is an institution and they're doing this research and they're being driven by literature, you cannot get the right issue from literature, but you will get the right issue, for instance, when you're in touch with social movement actors and when you align with their identified priorities and realities. So that's just in a way to capture, some of the gaps that exist between literature and knowledge that is held by practitioners.
That's so good. And so when you look at this, when you're able to identify the gaps, how do you see something like this ebook, this publication? How do you see the findings and those insights being helpful to other practitioners, academics, and other actors in the sector?
Right. So I think what's most useful is related to something that we also identified to be the biggest barrier. So when you think about the biggest barrier to case sourcing, so when we're saying we have this giant gray area where hectic violations, no cases. So what is, when we're trying to point out what is happening in the in-between, in this in-between gray zone, and one of the challenges is that of legal empowerment. And the challenge of legal empowerment, interestingly, cuts across all actors. So usually we think that, it's victims that are lacking in legal empowerment, but we find that even lawyers, for instance, are lacking in legal empowerment. So I think one of the strongest learnings for all actors that we can derive from this publication is that, like I said, everyone in this room knows a narrative, knows a case, knows a violation, but how can we transform these stories and these narratives into cases? So let's say for lawyers, that could mean, and as I said when I was introducing myself, my journey as a lawyer has actually involved a lot of unlearning. I learned a little in the beginning, and then the rest of my journey has just been unlearning, for instance, this positivist inclinations that we have as lawyers, where you take the law as truth and as all there can be, so learning to question, how can we get lawyers to question the law, that to see that the way this law is interpreted is discriminatory, for instance. And so and I know that when Sibongile speaks about the work that Isla does, this is some of the things that we're trying to achieve, in terms of how can we have a pool of intersectional feminist lawyers who have this discomfort, when they interact with the law, just to see when you're receiving cases, and can you tell patterns? Are you able to see this strategic angle, or are you able to see this entry points that are staring you in the face, or are you just processing one client after the other with a similar story, and you're not asking yourself, okay, clearly the challenge is not with these clients, but it's with this law, so for lawyers to be able to be in this zone where they can question the law. And then, for other actors, when you think of actors such as fast responders, typically most victims will not end up in a lawyer's office first. So they will end up, for instance, in a clinic. Let's say it's violence, it's on violence against women. They'll end up in a gender violence recovery center. Or if it's a trafficking, a woman or a girl that's been trafficked, they will end up in this type of shelter or this organization that deals with women who have been trafficked. So all these who we refer to as fast responders, are they also to have this, are they able to have this consciousness where, as I said, you're not processing one person after the other without saying, okay, maybe there is a violation here. Every week, there's a woman coming to me. She doesn't speak the language of our country. Clearly, she's a foreigner. She doesn't have her passport. She's banged, broken, and bruised. So, or do you just, forward to clinic, forward to shelter, forward to clinic, forward to shelter, without asking yourself these questions? Or what questions can you ask? Or who can you make an effective referral to? And, once the referral is made to NGOs, for instance, as typically happens in our continent, are these NGOs also, do they have the capacity to see that strategic angle? So I think, so all this is to say that for all actors that would be involved in order for us to have more cases, because that's what we're trying to achieve, right, for women's rights and sexual rights violations. In all these actors, there needs to be moments of deep reflection and learning and unlearning, such that we can all be able to see this strategic angle and make sure that the right cases end up in court. Another big learning really that comes out from this publication is that, we are all working very hard, and in this sector, we are all overworked. Everyone is working very hard, but sometimes, that there isn't like a proper fusion of efforts. So there's a big need for collaboration, for coordination, for movement building among actors to ensure that, because the first responder, for instance, has all the victims. Then there's this NGO that has the knowledge, but without the victims. Then there's the lawyer, but there needs to be a system. There needs to be more effective coordination. Yeah, and I suppose there's something for everyone. There's something for all actors to learn from the publication, at least those ones involved in litigation of cases.
Thank you for that. Thank you, Dr. Miriam. We're going to move on now to Dr. Abiola, and who is an expert and a practitioner. And so my question for you, Dr. Abiola, is based on your experience in Nigeria, what would you say are the opportunities and challenges for case sourcing gender and sexuality cases? I think we may have temporarily lost.
I think we have. Okay, fine. I mean, whilst we kind of wait for her, I do think that some of the opportunities, and challenges that we see, I mean, not only in Nigeria, so she will come back and explain that. But I do think that there is an interest in feminism that we are seeing, this idea that feminism is kind of going mainstream. And there's also a kind of a renewed interest in the use of the law, in like kind of South Africa and Twitter streets, there's something called LLB Twitter. And so there is this kind of idea that these are going to merge, because we have seen this kind of organic kind of movements, whether they kind of social movements or this kind of conversation, because where they do take us, if they are not obviously contaminated by disinformation, is what kind of Mariam was talking about how do we say these women cannot all have the same problem, let us look at what's wrong, with the law. So we saw this even with the defamation cases, the gaps around what does it mean to have Me Too in Africa, that other people had Me Too and it led to some of these changes in their systems in the global north. But what we are left with is women who are in court without the legal and financial support that Me Too had in the form of Time's Up. So Abiola is here, and then I'm going to start.
Right. Can they allow me to share my video? Okay. All right. I'm just trying to see whether I can share the video, but before then, I went off, so I don't know whether the moderator want to ask the question.
Yes, Dr. Abiola. I had a question. I just wanted to find out, in your perspective, what are the opportunities and challenges present in your experience for case sourcing gender and sexuality cases?
All right. Thank you very much. And I want to thank the previous speakers for raising some of the very potent issues that are also very applicable within our own context in Nigeria. If we all recall, when during the military era, the Nigerian civil society actually activated cases, at the African Commission. And if you look at some of the cases that were strategically brought to the African Commission, that time were led by Nigerian activists. So meaning that ordinarily we should have a history, of litigating strategically. But if we look at that from the context of feminist litigation in Nigeria, it's really not, it's just, I would say it's just evolving. There are very few trial of strategic litigation that have had of recent. Okay, I'm trying to, all right. There are very few trials of strategic litigation that we have had, of recent, and of course there are also very successful ones. But the challenge has always been, first, the question of knowledge is also very critical, because it's not the fact that you are a lawyer or you're a graduate of law, makes it easy for you to be able to determine or define cases of strategic litigation. So and I know that for quite some time there were some trainings here and there, but that has also not really been enough, to support effective feminist strategic litigation in Nigeria. So there are issues of identifying the right issues for strategic litigation, which I think it's always very key, and that needs a lot of things. As a lawyer, you have to also be very creative, in terms of understanding how to develop and gender and sexuality cases in a manner that you will be able to frame and present, to the court, so that it will be very strategic. And also the other issue is also about identifying actors, that can support the development of that case. So I think that one of the challenges that we have had is that knowledge, to be able to frame and also to identify actors that can. So looking at that from our experience, for example, I think in 2003, we tried to challenge the issue of citizenship in Nigeria. And one of the first crises we had was, how do we identify who is going to be how do we develop the case around, the issue of citizenship, which is a constitutional issue. So building the case also becomes like a problem. Especially because at that time, local standard was important. You need to have locals to be able to come to court, to be able to say that you have an interest in a particular case. So for that case of citizenship, we had to find someone who is a Nigerian, who is married to an American, who was ready to test, the waters. So, and what it means is that it's not only going to the court, it also means that there are also some preparatory things that has to be done, which include applying to the internal the Ministry of Internal Affairs in Nigeria, asking for citizenship, for our husband, as a constitutional issue, as a constitutional, as a thing of necessity at that point in time. So after doing that, so we got a letter from the Ministry of Internal Affairs that she cannot register her husband in Nigeria because the Constitution does not allow for it. So we had to then go to court, to make that argument, for as a strategic litigation to support quite a number of other women who were in that kind of situation, in Nigeria. So my point is that, so looking at that experience, so research was very important because we have to build knowledge around the issue of citizenship. We have to also find out processes, that could lead us to, even appearing in court, to be able to, push for that case and all of that. So the other thing that I want to also mention in terms of challenges has also been the issue of victim reluctance, especially if you don't believe in the court system. We found out that a lot of people seem not to believe, in the court system. So trying to then get, actors to join in cases then becomes very important. Also because they also know that the victory for those cases might not even come, on time, or decisions on those cases might not come on time. It will probably take, a very long time. So in our work, so that has also become a problem. And also getting, for example, one of the cases that we've done is around the maternal mortality issue in Nigeria. As you may be aware, Nigeria is next to India in terms of the number of women who die while giving birth. So we have engaged, a lot of women in that regard to try to put up some cases. So we have been successful in about 2 cases. One about detention of women after giving birth because they cannot pay, which is something that's very general and seem to affect quite a number of women. And also the issue of maternal mortality as a right to life issue. This have been brought before the court, but of course, the other issue is also about the judiciary also not having that knowledge to be able to relate some of the strategic litigation issues and also adjudicate appropriately. So my point is that the knowledge base is, yes, one within the movement, the feminist movement generally, there's a problem with the knowledge development issue. The lawyers also, there's a whole lot of challenges with creative lawyering and also on the judiciary aspect. And also, just as the report says, the issue of the actors, I don't want to call them victims, people who are working with us in terms of litigation, also understanding the need or identifying why this has to be done. Now, one of the opportunities that have come across is the annexing social and legal theory. So what we're trying to do is to look at the law and also do some kind of social mobilization to help us in terms of sourcing and identifying, the cases. So we have like paralegals across the country, that also support to identify, cases that can, be developed. The cases that we have adjudicated for ECOWAS, for example, came from some of those paralegals from around communities who found a right violation, then which also, led us to putting up some of those cases, before the court. So there are also other issues with respect to the social context, which I think in the source document we call the issue of legal issue of packaging, of cases. There are a whole lot of things that comes with it. The expectation from the victim who feels that she needs to win the case, then also the fact that victim also have other needs which addressing from a legal point of view cannot only solve. For example, the case of Mary Sunday, that was taken, we took it from a more holistic perspective. We looked at the trauma counseling level. We raised money for her. We went to court for her, and she got the judgment. Islam was also involved in that. So my point is that I think that one of the things we need to be doing to do is to expand, to expand our response as feminist litigants, undertaking strategic litigation, to know that it cannot just be a single barrel process where we go to court, we adjudicate, we get justice, but we must expand upon, and that's what I'm saying from the book, that we need to be holistic in terms of feminist strategic litigation, because it's actually different from the other kind of litigation that people do on a daily basis.
Thank you for that detailed response, Dr. Abiola. And I'm so glad because you touched on some of the questions, which was my next question around the barriers to the critical aspects of case sourcing for strategic litigation. And you've already highlighted a lot of them here. So my next question to you is, in light of all those barriers, such as the issue with the judiciary, lack of knowledge in legal practitioners, client reluctance, and all those other things that you highlighted, what have been the best relationships that you have cultivated to help you source a case?
Relations que vous avez cultivées pour vous aider dans le sourcing des cas. Une des choses que nous allons faire, c'est d'annexer, avoir comme annexe le pouvoir des peuples. Coordonner avec les médias. Les médias sont très importants. Juste, nous assurons que nous sommes avec chaque temps, nous sommes avec les médias. Et pour que
work with the community that it's our target audience, whether it's a pregnant woman, whether it is a woman who had suffered violence. So we engage in quite a whole lot of things. For example, we have had situations where we had press conferences like over and over. So we don't only use strategic litigation, we also build some other things to support the strategic litigation. So we have also engaged in protests. We ensure that people go to court so that we know that the matter is not just about maybe Sunday, it's also about all of us. So we've used that kind of method, coordination and mobilization, to support strategic litigation. We also build on community of practice. We work very closely with organizations like ISLA, Center for Reproductive Rights, HRDA in Gambia. We also work with Sarah because we also believe that the community of practice, for example, if we have documents, we share, so that we get vetted also by, other organizations that already, have been into the practice of, strategic litigation. And that has really helped in building the work we do around feminist strategic litigation.
Thank you so much, Dr. Abiola. So I'm going to open up the floor for questions from our participants. For everybody who is interested in reading the publication, please note that there is a link that has been posted in the chat group. And if you follow that link, you'll be able to access the publication. You will also be able to, if you don't get it here in the chat box, just follow all of ISLA's social media spaces and you'll be able to see where you can access the publication and hear more information on that. So if you have any questions, please raise your hand and we will be able to give you an opportunity. Whilst we are waiting for some raised hands, I see that there is a question here that I am going to ask Sibo to just answer briefly. And that question that was asked by Yolanda Millen in the chat about to what extent is the failure at a national level to adopt statutes that are meant to protect human rights an element of concern in case sourcing. And the example they use is that there's a convention against torture and other cruel, inhuman, and degrading treatments, but it only has 83 signatories and 20 ratifications. Looking at the situation in Zimbabwe, they don't investigate human rights issues there.
I think when we know what the law is supposed to do, then it becomes easier to identify the legal gaps because we know that is the law. So sometimes when talking to lawyers, I always say, lawyers, that the work that we do sometimes sounds or seem contradictory because we talk about the respect for the rule of law. And the starting point is sometimes like the law is just, the law is what must happen. But the work that we do is often about why is this law the law? Because we are challenging and we are questioning that why does this law make sense when it actually does not see women, when it actually makes it harder for women to get legal recourse or justice when they go to court. And so as lawyers who are trained in the common law system about what the law is, the law meaning what is right and what is just, it is sometimes very hard to put yourself in a position where you have to challenge the law, because many people, when a client comes in, they identify the legal problem, they know what the law is, and they help the client to use the law, and sometimes they tell them that the law does not allow that, and then that's the end of the case. But it is those, so if you have looked at international human rights standards, for example, or you have looked at comparative case law to see how other countries or also other kind of mechanisms have used those standards to advance kind of women's rights or rights of LGBTQI people, it becomes easier to argue that the failure to domesticate or to accede to treaties is a violation of people's rights, or to say that people who have ratified but have not domesticated are violating kind of people's rights. I mean, sometimes you've got standards like legitimate expectation that when you have signed at the international level, then the citizens have a legitimate expectation that those laws are going to apply. So I do think that when we know what the gaps are in the law, then we stop seeing our laws as the law or as just, but it becomes easier to think about them as something that can be challenged or something that can be made just so that the law can see women. And normally we find this when we've had, so the past 2 weeks we were in Kenya with lawyers from a number of countries. And for the first time, we're working with lawyers from Francophone, which is a civil law system, and lawyers from common law system. And I think what has just been wonderful about that, it's just this week, lawyers have gone back home, like really thinking about what does it mean to think about the law? So for example, in many countries in Francophone Africa, the only legal system, marital regime that's recognized is civil law. So it's 16 hours. Statutory law. And customary and religious marriages are not recognized. So in the conversation, when people hear how other people have actually used the law or what their national laws or their court decisions have said, so people now are beginning to see this exclusion of customary and religious marriages in a completely different way, because what does it mean to decolonize the law? Why would you use a received law that came with French colonization as the only law that applies in the country? So when people understand or when people know what they deserve in the domestic law, then it becomes easier to fight for the application or the implementation of those kind of standards at domestic law, and then to go to court and say there is a gap in the law, but you have to know that there is a gap in the law, and that's how you know.
Okay, thank you, Sybil. My next, please note to our attendees, you are more than welcome to ask questions. Please put your hands up and we will have our tech team unmute you. We want our conversation to be as robust, and we are looking forward to your questions. A question that I have here that I will direct to Dr. Abiola in particular is from Rose, that she posted in the chat about the issue of the reluctant client. And I'll read her question. She says, I also know many women who are not comfortable with the formal justice system because of time taken to determine a case and the cost. How do we go about using traditional justice systems to bring justice closer to women, well aware that most traditions are deeply entrenched in patriarchy?
Well, thank you very much. Yes, we normally we find a lot of women who are very reluctant, and it's also because of our background as women. Some majority are not very well educated to even understand the benefits of the court system, you know. But what we try as much as possible to do is to explain to them about the benefits of going through all the all, and also to let them understand that the issue is not just about them, and also let them recognize the fact that there are several other women, you know, who are in the position with which they also found themselves, and that being part of this process could also help, you know, in addressing that point from the legal point of view. And I think in that regard, we have been quite successful in that persuasion of women. Using traditional justice system, I think it's important, also given the African context, to address issue. And as you said, we know that it's a very patriarchal system, and it's also a very informal system. So meaning that the jurisprudence often that time they are not coherent and also not very consistent, especially in a country like Nigeria, where we have about 250 different ethnic diversity.
250 de diverses tribus ici. Et le problème, c'est que si nous voulons adresser chaque tribu, nous pouvons adresser ce qui n'est pas très vraiment utile. Donc, la litige stratégique a le focus sur le problème et aussi avoir un objectif féministe. Il y avait un point, nous sommes arrivés à un point que le juge a posé la question que si
it's a constitutional issue, and that's to be dealt with constitutionally. So what he then asked us to do beyond the strategic litigation is to say, yes, it was discriminatory, but it was not within his own jurisdiction to be able to define constitutional issue. So we can only engage legislative advocacy in that regard. So, and that's why the point of holistic engagement on the issues of gender equality and sourcing for cases also comes in. So what we then did is to begin to work around gender review of the Constitution to ensure that the issue of citizenship is addressed. Unlike if you compare this case to the case of Litigate against Dow, where the judges were much more creative and more daring, to offset, some of the issues that were in the status, and then we got the case of Litigate against Dow. Thank you.
Thank you for that answer, Doctor. We have a question from Omoumi. You have your hand up.
Yes, thank you. Thank you so much. One, for organizing this. I think for me, this was just the right moment for me to be in a webinar like this, because I'm just starting some readings on international criminal law, and I've been thinking of what African legal feminists would have to say about this. So this is really useful, and I think that's why one of my first questions, especially to Dr. Miriam Kamunyu, would be, what are those African legal theories? Because in my search, it hasn't really come up, and it's difficult. And I know this may be tied to the whole knowledge production and how, maybe knowledge coming from the global south is devalued and not published as widely as, knowledge coming from the global north, or even knowledge coming from Western feminists, so I would like to be educated on that. And my second question really is about this decolonial approach that, Sibonile talked about earlier, that if we recognize that we inherited colonial systems, that sort of makes us, and I see this in some literature, they some Western feminists call us carceral feminists, that we're pushing for too much of the law without really, as though we believe so much in the law, but if we were to take a decolonial approach to women's rights issues, because that's why we're considering litigation, right? What would this look like? Would we be asking for a dismantling of the current justice architecture that we have within our countries? Or do we believe that the current justice architecture that we have, does it really serve women? Are the international human rights standards even, does it even serve African women? Shouldn't we rather be asking for, what someone said earlier about the traditional system, something that is more African, that we sort of, believe in?
That question was for you, Dr. Miriam.
Okay, great. So I think a short answer to this is really a way larger discussion, and I will make a book recommendation for your very wonderful book by Dr. Sylvia Temale that really speaks to colonizing African feminisms. But I think when you ask, what are these African legal theories? And, African feminisms are many, but my simple response would be, whatever theory it is it one that aims, an African feminist theory is one that aims to, surface the exclusionary nature of other theories, by that is conscious of and responsive to the oppression of African women in all their manifestations. And when you speak of African women, seeing women in their diversity, so it is a feminism that is intersectional, right? So that's one of the things. It must be a feminism that is intersectional, meaning that it sees African women in their diversity. So not just seeing women as this plain homogeneous group, but seeing women in their colors, seeing women as lesbians, seeing women as women with disabilities, seeing women from rural spaces, from urban spaces, seeing, so seeing women in all their identities. So that is why there isn't really like a single African feminism. There is the idea of African feminisms. And as I'm telling you how to identify its strains is, if it's surfacing this oppressions, and, it's also acting as a shield to discrimination, while at the same time also acting as a tool that you can use to challenge, to overturn, to challenge and to overturn gender inequalities, patriarchy, unjust sexist practices. So it is really a feminism that is protective, but at the same time questions, questions even, and the unique thing about African feminism is the questioning that you're even talking about, questioning even knowledge that exists within mainstream feminism in terms of, is it really applicable to us? So, and that's that's the idea you're talking about, decolonizing even our understanding of knowledge. How did this knowledge come to be? How was this knowledge created? Who are the creators of this knowledge? And so just saying that those are the various elements that you would be thinking about when you're thinking about African feminisms. In short, in one line, is it responsive? Does it see the lived realities of African women? And is it responsive to these realities? And African women always with that asterisk, and even now I would put an asterisk even on our no frequent use of when we say African, to the understanding that we're using this term African just for geopolitical convenience, but the understanding that, you even need to nuance that idea of what exactly, like you need to nuance that idea further. So not to carry along with you also this Western view of, Africa as a country. So it's just a lot of nuance, a lot of questioning.
Thank you.
Yeah.
Thank you for that answer, Dr. Miriam.
And okay, great, sorry.
Yeah. Yes, continue.
I wanted to respond to the question that Flavia asked.
Yes, I was going to read that question out now. Thank you so much. I'll read it out for those who perhaps are not able to read it. So Flavia asked a question here. She says, another challenge, especially when litigating on cases touching on social norms and culture, etc., such as FGM, there is the fear of reprisals from communities. Families and or survivors feel they can only go through with the litigation if they move away from their communities, and this then becomes a barrier to proceed in certain cases. It would be interesting to hear reflections on how others have navigated this challenge. I please go ahead and answer, Miriam, and I'm going to ask Sibo to hop in here as well with her extensive experience in litigation.
Yeah, no, the reason why I was eager to ask that question is that I saw it very much related to the question that Rose Wakikona had also asked about, how women are uncomfortable with the formal justice system. And I wanted to speak about something that Sibo brought about earlier, and this idea that we need to have when we're thinking about feminist strategic litigation, this idea of the right client. right? So when it comes to strategic litigation, you know, I'm seeing there's a sense of where, from these questions, whereby you feel, oh man, I have this client, like she's reluctant, but I feel like I must go to court with her, but like, so you really must not go to court with every client that, you know, comes to you or comes to your office. So when you think about, if we're to ask ourselves, who is the right client, you know? And when you think about, for instance, the example that Sibo gave us, that in litigation surgeries across, I don't know, it was over a decade, 60 cases, and only 3 went through. And what was the common strands between the cases that went through? It's because the right client really, they were connected to social movement. So when you're thinking about, should I go to court with, because there needs to be a merger of the right client, the right facts, right timing. Should you go to court with this client? Is this client that understands the strategic elements of the litigation? So it's not just a client that's been violated that has a good case. And who are these people that typically understand the strategic element? You know, typically you'll find that that's why, for instance, activists make the best clients, because they are embedded in social movements, or they're able to see beyond my personal interest. This case really holds the key for monumental social change, for monumental social impact. And, you know, so, and this client is then more likely, for instance, to persevere. And in now answering Flavia, she was asking, how do you navigate this? You know, you then pick a client that is able to persevere the challenges that come with strategic litigation, you know? So if a client is carrying with them the understanding that there's massive social change, then they are in a better position to bear the personal cost when they're cognizant of the larger, you know, societal impact. So, but if a client really has to deal with a lot of personal affliction, there's reprisal from community, from family, and they don't have this other deeper, bigger picture of what is it that we're trying to achieve here, you know? What is it that we could achieve with this case for jurisprudence, for laws in our country, for many other women that will come after me? So you really have to look at your client and ask, you know, do they have this understanding? And another client that then becomes suitable then is an institution, right? So you can have the victim, but the victim does not need to be the client. The institution can be deemed to be the right client. For instance, in these situations where you're saying you're very reluctant clients, or for instance, the safety concerns are, you know, overwhelming, or the clients, you know, sometimes are unavailable, or there's a issue that needs to be surfaced and there is no client, there is no individual client actually, although the institutional client does come with its own challenges, you know, because the case could lack a human face. But just to say that when we are thinking about the right client, we also need to think about, are we able to care for this client? So if, for instance, you're saying at this point, you can already identify the various risks that they will face, are you able to fully meet the needs of this client in what we refer to as the package of care, or the basket of care? Can you meet the psychosocial needs? Can you meet, what is their income going to look like during this time? Or, you know, when they're experiencing all the, is there access to a safe house, for instance? And so, for instance, if you find that you can't meet the holistic needs that your client has, then again, this is not the right client for you. And you really should not be proceeding with a client that you cannot care for, that you cannot protect. So I was just saying that, you know, there is no need to feel, you know, this thing like they have this client, the case is great, we must really go with this client. There are questions that you really must ask yourself and conclude, do I have the right facts, this is right timing, but do I have the right client with me? And sometimes that can be no. The answer to that question can be no. Sibo, if you could add
on. I think just to add a bit, it's the kind of clients I think that come, you know, to you. So for example, many people who see LGBTQI people who have been arrested, you know, and then think, oh, maybe this could be a very good decriminalization case, or a case to deal with police harassment. I think one of the things it's really around the vulnerability of a client. And sometimes when you have clients who feel like they owe their lawyers something, and sometimes they may go ahead with it, because when you think about what it means to be arrested and the prospects of facing imprisonment, that for many people, they may say yes, because they have a lawyer and sometimes they understand, or sometimes they don't understand what it means to be a complainant in a strategic litigation case. So I do think that as lawyers, in as much as we want to develop legal standards, that one of the things to be mindful of when we see clients is to think about what is, once again, the thing that motivates this person. Is it a person who wants a lawyer because they want to go out of court, out of this case, but once they're outside, that it's like, I don't need this, I didn't come asking for this, I was arrested, and that's why I saw a lawyer, but I never had an interest in challenging this law, right? So that's one of the things, because we might have identified it, and I think that has been one of the biggest criticisms of strategic litigation, that it can be so lawyer-centered, because you can see how these clients, these facts can actually help you to challenge the law and then develop legal standards and greater protection for people in that class, or people who may be vulnerable to those kind of laws. So I think one of the rules right now has to be, do not kind of go after desperate people, but it doesn't mean that they need to, but just make sure you understand what the person is actually consenting to. And one of the things to inquire is, what is it that motivates the person, and is this what they wanted? And sometimes, we have public interest organization, sometimes we do legal aid. People, sometimes they just want legal aid and they don't want to be part of this. And throughout history, there have been very many examples, I think, of a case that is celebrated, but actually didn't bring that, for the client, but it brought that for the lawyers, like when I was a domestic lawyer, I think from 1999 to 2007 in South Africa, most of the landmark decisions, the South African Constitutional Court, we really dealt with a number of disgruntled kind of clients, so out there it was like celebratory champagne moments for lawyers. But if you have gone to develop the law and the victory is really that the law does not discriminate anymore, the client does not necessarily get money. So it's like, what does it mean to be all over kind of TV, newspapers, have journalists come to my house and you tell me that the law has changed? It's like, what do I get, out of it? So I think being able to explain, some of those things to people, that what is important is that even if it's a tiny room, but like an informal settlement, that your case was important for us to advance the law, but your life is not changed by the case. It simply means that you get to stay, in your house as is, with the same conditions, basically, like it's not going to change your fortunes. And sometimes I think as organizations that do this, sometimes we don't have the capacity to do the extra. So imagine someone who wants to sue someone who violated them, for example, as a child, and you are able to get the law to say that, there shouldn't be prescription in child sexual violence, so you can come back at any time. It's such an important thing, right? The lifting or the removal of all of these barriers. But what does it mean for that person when they are not able to get compensation because maybe the person has gone and moved the money kind of abroad, or the person actually that they are trying to sue has no money? So the case has been litigated, but they're not able to get the financial kind of recourse. So sometimes being able to think about the bigger kind of legal and policy change that we want, but also thinking about what does it mean for the person who is there to kind of represent. And that's why in these kind of cases, it's really important that we think about the motivations beyond, whether kind of financial compensation and all of that, because we know what we want to do. We want to be able to use the law, for social change. That's what we want. That's why we do strategic litigation. But most of the time, people who do not come, from this background, for them, it's the individual kind of compensation that is important, for them. So the issue of the right client, and I think this is what the publication is also trying to emphasize, is that it cannot be. And there are just so many things that you have to inquire kind of into. And these are also things that actually come up in most of the gender and sexuality cases. So when you imagine, I mean, it's the same case that Flavia is asking about in the kind of answer box, with the question box. If people fear that by going to court, they are going to alienate themselves from their family or their communities because of the kind of issues or the shame that they have brought in there, they would want to find a way to resolve this amicably other than having a case that's like all over national news, the Constitutional Court, or globally. But also when you think about the shame, the stigma that comes with cases of sexual violence, people would not want to go to court and say, I was raped, by my husband. So I want to be able to challenge the failure to criminalize marital rape, So sometimes the violation is very clear, but there are all of these things that are actually standing there just to say, it's really not possible to go forward with this client precisely because of where they find themselves. And I think the most difficult one cases, I think, for me has been the violence against women, because we understand trauma and that trauma affects people very differently, and that from sexual violence, a lot of trauma can come from there. And sometimes you find a person who wants justice, but it's there are a lot of struggles, even the legal process itself, with the secondary victimization that it brings. A person is just not there. And I think here it's a very hard choice, because one, you just have to find out if there are any predisposing factors right from the beginning that will make it harder for the client to proceed with the case. But also you don't want to say, you have a lot of trauma, so I am not going, to be able to go to court with you, though even though you want justice, but I really do think that you don't present, kind of wow, as a client. And I think that's how in the book we talk about this basket of care. Like, what does it mean to support clients who are willing, but they have got other things, that they need to be supported with in order to be able to stay or invested in the litigation process.
Thank you so much.
Yeah, sorry, Nobu, I think there is someone who has to come in, right? And make an intervention, and it's Sinao before we close. Sinao from Sinao is a writer, a blogger, and many things. And if you go to African Feminism website, you are going to see, we are also going to post a link, but she did an article about the publication. So Nobu, over to you to hand over to Sinao.
Okay, sure. I was with Sinao after any final closing comments from Dr. Abiola or Dr. Miriam, just in closing, and then Sinao can please come in. Dr. Abiola, do you have, if there's nothing, that's perfectly fine. We can continue. And I will hand over to Sinao, and then we will close.
Okay, moderator, are you asking me to say something? I missed that.
Oh, I was just saying your closing remarks as we're coming to the end.
All right, let me just say some few words. Thank you very much. I'm just wondering about the issue of the right client. And I'm just, I think that there can never be, we would always have clients. You can have like 100% right clients. So I think there are also issue of advocacy. How do you engage the clients? Because I think our work is also about, getting people to understand from a feminist lens, some of the issues we're trying to bring to fore. Yeah, some would be successful in doing that, and others will probably might not be very successful. But I think it's also important for us to try to bring our understanding and knowledge, of what we are trying to achieve, to the table of the client. oftentimes what we try to do is to have a deep conversation with the client, before starting off, so that the clients, and also carry the clients along all through the processes, so that even if the client has challenges in understanding the issue, we ensure that we make sure that the client gets to a point where the clients will be able to go all the help for the sake of women, for the sake of the nation. So my own point about the right client is also that we should not give up. There will be clients, and we know where we're going, and it's important for us to take our client along, as we go along the way.
Thank you for that, Dr. Abiola. Snell, over to you. Okay, go ahead.
Good day, everyone. Can you hear me? Can you confirm?
Yes, we can.
Oh, all right. Thank you so much. I'm not sure how to do the video. It's not showing on my screen.
All right. Sorry, now I think you need to accept the invitation to join the panel.
I did.
Okay, you hear Control? Okay, I see you now. Control, please allow Snao to share the screen.
I can start, it's fine.
Sorry about that.
I can start. It's okay.
Yes, please go ahead now.
Oh, all right. I just wanted to share some of my reflections as someone who was writing the review from a perspective of a feminist and someone who is a writer. And I really loved the publication and was introduced to the concept of feminist strategic litigation and understanding how it works as a tool that confronts, gendered exclusion and silencing of women and, sexual minorities. And the publication did a very good job of also introducing strategies to combat this reality, as we all know that we live in a society that has always disadvantaged women, even when we try to empower ourselves by asserting those rights through the justice system. I think one of the things that were a big takeaway from me were the recommendations on how to go forward, using things like legal empowerment, and collaborating and coordinating and working together as feminists and the law system and lawyers who are passionate about advancing the human rights and access to justice for women and girls. And I think for me as a feminist and as a writer, it was so important to see, the background work that goes into how this happens, how the dismantling of oppressive systems goes about. And, it made me feel like it's empowering to see this kind of work being done and understanding how it impacts me, not just as a feminist, but knowing that even after other women in the African continent can be helped through female strategic litigation.
Okay. Thank you for those reflections, now sweet and straight to the point. And if you check out Isla's social media pages as well as African Feminism, you'll be able to see the blog post that Sinawa wrote. It is very insightful, so please do check it out. We have come to the end of today's proceedings, and I'd like to thank all of you on behalf of Isla for attending. Thank you. A big shout out to the Isla team, always for showing up. Thank you to the tech guys for running the Zoom meeting. Big thank you to our panelists, Dr. Abiola, Dr. Miriam, and Sibongile for availing yourself this afternoon. And an extra thank you to Dr. Miriam for putting together the publication. As stated, they are links in the chat box for to access this recording, to be able to access the book that was recommended, to be able to access all the stuff that was discussed. If you check in the chat box, you'll be able to find all the links, or please follow us on our social media platforms and you will be able to see what's happening. This is the first of a series of publication releases. So please do join us again in 2 weeks on the 5th of August, where we will be discussing Isla's proof of concept on African feminist litigation. It is going to be a very exciting discussion, and it is one that I'm very looking forward to. So I hope you will all be here and bring along all your feminist litigator friends, as there's much to be gleaned from the experiences of Isla and her collaborating partners. Once again, thank you everyone. Apologies that this meeting has gone on for a couple of minutes longer. Thank you for your indulgence, and we will see you on the 5th of